there, this is attorney Sarah Holmes of Holmes Business Law P.C. We are a business and trademark law firm that also offers general counsel subscription services to business owners. Today we're talking about a question we get quite often, which is how to choose your business structure, LLC versus S-Corp. So this is something that comes up nearly every day in our office, and we find that a lot of people really misunderstand what is an S-Corp and how is it different from an LLC and how is it different from a corporation. Now, the first thing you have to keep in mind is an LLC is an entity formed with your state, limited liability company, and the shorthand thing to refer to it is LLC. An LLC is an extremely flexible entity for your business. In fact, LLCs were created by most states in order to give small business owners a lot more flexibility than they normally would have had with a corporation. For example, with a corporation, you traditionally have to have bylaws and meeting minutes and resolutions. With an LLC, you're not required to have any of those things to keep the protection of the entity, so it can be much easier to manage. Also, with an LLC, you can have a pretty complicated ownership structure if you get help and you kind of get someone that knows what they're doing help you set it up. For example, we can set up LLC structures to very strongly mimic a corporation. For example, we can have members with different voting rights. The members can be other LLCs. And generally, you're not limited by the number of members in your LLC. Typical documents you'd have with an LLC is obviously the certificate of formation or whatever formation document your state uses. You would have an operating agreement. If you're a sole member, that may be a very simple couple pages. If you have partners and other members, that should be a more complicated document, spelling out all the rights and voting issues and equity of the members. But ultimately, it's a very, very flexible entity. Now, the downside usually to an LLC is this whole issue of how the business owner would be taxed. By default, if an LLC is a single member, it's taxed by the IRS as what they call a disregarded entity, meaning you're taxed as a sole proprietor, even though you have a legal entity set up to protect yourself. If you have a partnership, same thing. By default, it's taxed as a partnership, again, even though you have the legal entity set up to protect you. Now, business owners might find that at some point they are paying a lot of money in self-employment taxes, having it be an LLC taxed as a sole proprietor or taxed as a partnership. Usually once your business starts to acquire a good amount of profits in the business, you're going to find that at the end of the year, you're taxed on all those profits and it doesn't really benefit you to keep the profits sitting in the business. That's why a lot of times we find business owners whose accountant, they have a lot of profit at the end of the year, we'll tell them to go, make a big capital purchase, right, to reduce their tax liability. If you're in that type of position, you might want to think about setting your taxation instead to an S-Corp. Now, this is where we end up having people with usually pretty gross misunderstandings about what an S-Corp is. So an S-Corp itself is not an entity. There is no entity that you can form in any state that's called an S-Corp. Your accountant or someone else might tell you otherwise, but it's simply not true. Your entity itself would either be an LLC or the entity itself is going to be a corporation. The S comes in with the tax election because an S-Corp is subchapter S of the IRS code, and it's a tax election made for your entity, which again could be the LLC, which would give you more flexibility in terms of the administrative requirements and meeting minutes resolutions. Or you could set up a corporation, have it be taxed as an S, but you have to really abide by all those formalities. Like you need to keep minutes, you need to do corporate resolutions. And we know that a lot of small business owners are not doing those, hence blowing the protection potentially of their corporation. Now, let's say you do decide to elect S tax status for your entity. There are a number of restrictions for an S-Corp. So for example, number one is that the members or the S-Corp holders, shareholders, cannot be other entities. So for example, it can't be other corporations as the members or the shareholders. They have to be individuals. The second is actually a citizenship or legal residency requirement. They could be foreign-born people, obviously, but they would have to be citizens or legal residents in the U.S. So you couldn't have people here on temporary visas being business owners with you in an S-Corp. The number of shareholders is also limited. It cannot be more than 100, whereas an LLC, you can have as many people as you want. The other restriction would be that an S-Corp can only have one class of stock, which if you want to set up a more complicated structure, for example, having a certain class of stock with superior voting rights than another class, or other withdrawal rights, maybe buyback rights. You cannot have that in an S-Corp. You can only have one class of stock for an S-Corp. So you have to really weigh carefully whether the tax advantages are going to make sense for you. We are not accountants, so we can't give you tax advice. But we tell people that if you get to a point in your business where you get to the end of the year and you have a lot of profit sitting in it and you want to keep that profit in your business, it's time to have a discussion with your accountant as to whether electing S-Corp status is going to be beneficial to your business. So, of course, if you have any questions, you need help setting up an entity, we're happy to help you do that. Our phone number is 215-482-0285. Thanks.